Speak with some stakeholders in the administration of criminal justice on the subject matter. For more insight on the subject matter, we have Eko Ejembi Eko, Senior Advocate of Nigeria. We'll begin by asking you, what is the place of a witness in a criminal trial proceeding?
The witness is the gravamen upon which the facts as alleged are usually provable or proved. It is the testimony, the evidence that the witness provides that makes the difference between whether you have a conviction or an acquittal. In a criminal trial, even in a civil trial, it makes the difference between getting judgment in your favor or losing a matter. Evidence on its own does not just take itself and walk to court. The witness brings it either by direct eyewitness account or by viva voce testimony, or even documentary evidence or real evidence. Most, however you cut it, for purposes of trial advocacy, the role of a witness cannot be understated. Even in arbitration, you can't get very far without witnesses.
There are situations where a witness or witnesses gave evidence in court and such individuals testified against unleashed terror on them. What kind of protection and support are available to these kind of witnesses?
Well, it still leaves a lot to be desired. Factually speaking, how are we protecting our whistleblowers? These are the people who we are hoping to turn to witnesses to support our allegations of corruption, to support allegations of even treason. We should do better to protect witnesses, but we're not doing enough. A man comes to testify in support of an offense done to the state. How does the state protect him? How does it stop him from this very big man or very influential figure or very terrible crime lord coming after him after the trial is over? If he survives the trial. Even if he doesn't survive the trial, what stops his cronies and allies from coming after him? That is where the role of witness protection comes in. It's a self-evincing thing. This person needs assurances of his own welfare to be able to tell you the truth that otherwise you could not have gotten. And it encourages others to see a wrong thing and come forward because they know they will not be victimized, because they know the state to protect them from victimization or being picked upon. But without that safeguards in place, you leave them to their own fate.
I believe the essence of the act is to take care of the anomalies to ensure that this works. How do we learn from other crimes to ensure that this act is fully implemented in Nigeria?
You can have all the beautiful laws you want, but without actual implementation and the facilities on ground, it's just wishing. On a dying star, if I may be so bold. Before now, the role of witnesses and their welfare is covered in most of the rules of courts. But how well is the letter of the law being followed? How well is the welfare of the witnesses being catered for? How well are the witnesses being protected? We heard of the famous whistleblower, I think in the Koi issue. Have you asked yourself whatever became of him? Did the matter eventually get to trial? And if not, why not? You see, some of these things are instances of our failure. You create a Whistleblowers Act to encourage people to report ills in the society without putting practical measures in place to protect them. It discourages truth-telling from an anonymous source. And it also discourages the anonymous author of information from coming out to say so. Without the protection in place for them, it will be suicidal to participate otherwise.
What happens if a witness who made a deposition in a criminal trial fails to appear in court to give evidence and to be cross-examined?
Every deposition goes to no issue. It's like pleadings. Pleadings that are not supported by any evidence. What does it go to? It goes to no issue. The man deposed to it then. He has not come to adopt it before the court. How do you know if he is not going to resign from them? How are you even sure that was his deposition? Some of these factual practicalities only come into play in practice. You have a piece of paper that you allege that Mr. A deposed to on a particular day before a particular commissioner of vote. Mr. A is not there to say otherwise. What if the other side alleges that it's forged or it never happened? In the state of our practice presently, it becomes a very, very hard ask to continue based on the position without the deponent coming to give evidence. It's abandoned testimony, if you ask me.
Do you subscribe to a pool of funds being made available to cater for witnesses who might have difficulty coming to the court to give evidence as captured in the act?
If it is going to be used properly and if it is going to be implemented correctly, I'll stand and applaud it. But there are so many lacunas in implementation that you begin to wonder, who is warehousing these funds? How do you get to know the need of the witness? How is he brought to court? How is he taken back? Look, the letters of the law are beautiful, but it's the spirit behind it that we are speaking to now. The law exists to cure a mischief, but is this mischief actually being spoken to practically? That is the question. It's not so much about having policies and laws in place. We must bring in a structure that will make those laws work for us. A structure must be put in place to make these things, take it away from the paper and bring it to the streets. That is what we should be looking at. Yes, I applaud the lawmakers. Yes, I applaud the executive. But then again, we need more if we are to move forward. In the rules of most courts, there is provision for welfare of witnesses to come to court. It's the practicality we are speaking. We can make 150 laws, but without the spirit to implement it, without the facilities and the structure on ground, without the actual will to so act, those laws are just academic. We need to look ourselves in the mirror and ask ourselves the germane question. What is the problem? Do we have a problem? How do we better the situation? Why are witnesses not coming forth? What can we do to protect these witnesses? Practically, not legislatively. So once we have come to that realization, once we agree on what to do, then the next step is how do we go about doing it?
Synergy between critical stakeholders in the justice sector, the courts, the law enforcement agencies cannot be overemphasized in ensuring the protection of witnesses. What's your take on this and how do we get it right?
Without them, it will never work. That's just the blunt truth. Most of these witnesses interact with them. They know the witnesses. They know the needs of the witnesses. They know where the witnesses are coming from. They interact at the most basic level with the witnesses. So if you don't take their views as stakeholders into play, then they are still running around in circles. For purposes of criminal justice sector, the lawmakers can make all the laws they want, but without the security enforcement agencies, it will not really work in implementation. That is just the hard truth. The people that go after these criminals, the people that have informants, the people that investigate, the people that do the hard work, they must be called in to have a sit down as to how best to implement this. In other crimes, there's a system in place. There are witness protection programs in other crimes. Let's just look to them. What we are facing now, the US faced it a long time ago when they were fighting the mafia. They established a very efficient witness protection agency and program and worked. They still do that in fighting drugs and narcotics, so to speak. Look to what is obtainable, what has been progressive, what actually works in other crimes, bring it home. Simple.